think we're ready. Need to raise this a little bit. Good afternoon, everybody, and welcome to the panel on conviction integrity. My name is Brian Tannebaum. I'm a past president of the Florida Association of Criminal Defense Lawyers and current chair-elect of the Innocence Project of Florida, and I'm honored to have been asked to moderate this important panel on the integrity of our convictions. I have, and I thought about it earlier, the four people that if I was innocent or needed some mercy from the system, I would probably want their cell phone numbers. So let me start with, from my left, if you don't know Reggie Garcia, you probably don't know anything about clemency in Florida. He, in a word, and I don't mean to have any implicit bias, but Reggie is the man. He is a two-time author. He's got 20 plus years experience in working before 4 different governors in Florida. He's a lobbyist. His 2 books are Second Chances and How to Leave Prison Early. He's a double gator, and his website is floridaclemencylawyer.com, and it's a great website if you want to go and find out really anything you want to know about the system in Florida. To his right is my hero, Seth Miller, the executive director of the Innocence Project of Florida. For the last 12 years, that's been his position. Before that, he was a project attorney with the ABA Death Penalty Moratorium Implementation Project in Washington, D.C., and a staff attorney with the first DCA in Tallahassee. He is a graduate of FSU and Penn State Law School. To my right is the elected state attorney of the 4th Circuit in Jacksonville since 2016, Melissa Nelson. She was a prosecutor in that office for 12 years, went into private practice, and then ran for state attorney in 2016 and was elected and has started a conviction integrity unit in her office. And let me just take a break. Someone who's not on the panel but sitting in the office, Shelley Thibodeau, is the director of the conviction integrity unit in the 4th Circuit, and we're honored that she's joining us today. And to her right, to Melissa's right, is Maria DeLiberato, who works in the Capital Collateral Regional Office here in Tampa. She's a former assistant state attorney in my hometown of Miami, and then unfortunately we lost her to Tampa. And she's been in this office now for 12 years. As you heard this morning, in 2016, she was successful in overturning the death sentence of Clemente Aguirre Jarquin, who's now beginning jury selection on his retrial in Seminole County this week. He spent 10 years on death row before his conviction was overturned, and she's also a graduate of Penn State Law School. So the way I want to begin this is I want each of our panelists to give a brief introduction of what they do and to define the term conviction integrity as it applies to their role in the system. So if I can, I'd like to start with Seth.
Thank you, Brian, and thank you for everyone for having me here. And I see a lot of folks that I've worked cases with on both sides of our system here, so it's great to see everyone. I sort of define conviction integrity very simply as getting it right. And when I mean getting it right in the Innocence Project context, it's about factual innocence. Is this the person who committed the crime? Once someone's convicted and sentenced and their conviction and sentences are affirmed on direct appeal, they lose the right to counsel in Florida unless, of course, they're on death row. And most of the folks in prison are not on death row. And those folks don't really have the kind of resources, investigative experts, money to hire a lawyer in order to investigate claims of innocence and bring those claims forward to the court. And that's where our project comes in. Our project was created in 2003 because there was a deadline on post-conviction DNA testing in Florida, which no longer exists, but at the time there was, and there just wasn't enough resources here in Florida to get all those people who had viable claims for DNA testing to prove innocence, get them into court before the deadline. And that was how our project was created, but we've grown into a much larger project. We're a freestanding nonprofit, and our main goal is to find innocent people in Florida's prisons and free them, and we work through all 67 counties, and we've gotten a number of people exonerated or freed through new evidence of actual innocence. That is our, and I'm sure Melissa will talk about this as well, that's our reactive work. Those people write us and we vet their cases and take them on. but conviction integrity is not only about reacting to cases of potential miscarriage of justice, but also trying to prevent them before they happen. And so we do a lot of training, both in Judicial College as well as public defender's offices. I see Carlos Martinez here. I was at his office just a couple weeks ago doing advanced DNA training with his lawyers. And we do that to help people become smarter on the front end so they can do their jobs better and hopefully prevent a miscarriage of justice. We also do policy work, both to update police practices that might impact wrongful convictions, pass or promulgate new rules or laws in terms of our court system to help prevent wrongful convictions. Again, the whole idea being to proactively prevent wrongful convictions before they happen. And that is where we sit in the criminal justice system as advocates, but both collaborative with all of our stakeholders to try to prevent wrongful convictions and correct them when we find them.
Thank you, Seth. I want to go to Maria. Why don't you let everybody know what it is you do and your thoughts, definition of conviction integrity.
Sure. Thanks, Brian. As Brian said, I'm at Collateral Regional Counsel, the Tampa office. We handle all of the capital post-conviction state and federal appeals after the conviction has been and sentence has been affirmed on direct appeal. So we're sort of the last line of defense. My office and our South and North office stand in between, potentially the execution of an innocent person. And so we really have to take a look at the case from the beginning. I have a case from 1976 where we've been seeking DNA testing for better part of 20 years and have been unsuccessful so far. But at the same time, we have new cases. The case that Nina spoke about this morning, Mr. Aguirre's case, was a 2004 trial. And for some reason, neither the state nor the defense sought DNA testing of any of the bloodstains at the crime scene. There was more than 150 collected. None were tested until we took over the case, and they pointed to the perpetrator, and she's subsequently confessed. And yet, as of course Nina said, they're still trying Mr. Aguirre this week. But I think that one of the things that I'd like to talk about, and obviously I know Melissa's going to talk about this a lot more, but when you get to my stage, we're throwing Hail Marys a lot of times at the court. And so one of the things that I think moving forward is helpful. We have a post-conviction DNA statute, but it's a very, very high burden to overcome, as it should be. I mean, I'm not saying that, every single piece of evidence in every criminal case, capital case, should be tested. However, I think that there needs to be a lot more agreement between state attorneys' offices, between my office, looking at critical pieces of evidence that were used to convict clients, and make sure that those items are DNA tested before an execution happens. I think everybody in this room can agree that the execution of an actually innocent person would be beyond a travesty. And so that's one of the things that I'm very interested in working on is finding these cases and working with conviction integrity units to do this testing that really will provide finality and prevent the execution of an innocent person.
Thank you. Reggie, you're dealing with Mercy from the executive branch, so talk about briefly what it is that you do and how conviction integrity plays into your role.
Sure, and thank you for having me, and Michelle and Hank and others, the committee, for organizing this. I'm a Tampa native. It's great to see so many friends here. But the focus, and I reread, and if you haven't yet, please, I commend it to you, Barry Schenk's 2017 Law Review article that really goes into this from a textbook standpoint. And the experts will tell you today that this is going on, both the facts and the science, and trying to establish actual innocence at the trial level and at the trial court level and at the appellate level. So you might wonder, well, what, if any, connection is there to clemency, which is the governor's power to grant mercy under the Constitution, or what, if any, connection there is to parole, which we have 3 parole commissioners. It's now called the Florida Commission on Offender Review, but for most of our lifetimes, it was referred to as the Parole Commission, which the legislature has told them very specific criteria, what you can consider aggravators and mitigators, and parole is an act of grace. So what I would hope we could explore a little bit later, not on the front lines at the trial level, and this morning's presentation was terrific on the two Texas cases, and I've sent around a case example of an 81 Tampa murder where my pro bono client, Felix Garcia, is serving life in prison to this day for a murder I believe he did not commit, and I believe he's factually 100% innocent. And hopefully one day the Hillsborough State Attorney's Office, when they get their conviction integrity unit up and running, will maybe take a look at that and re-examine that and talk to new witnesses, et cetera. So I see clemency and parole as somewhat indirect safety valves. Maybe the state attorney's office and the defense lawyers are 70 or 80% of the way there. We have a pending parole case or a pending clemency case. And the victims always get to make a recommendation and should. The state attorney's office always gets to make a recommendation and should. Sometimes even the presiding or chief judge. And informally or formally, those offices and parties may be in a position with pending clemency and parole to say just enough doubt has been created about certain convictions and certain facts and new evidence that maybe it tips the scale if it's a close case one way or another. On the parole side, I talked to Chair Kunrad yesterday. By the way, they normally meet on Wednesdays in Tallahassee. They're presiding as we speak in Lake County doing parole cases today. They move around the state periodically, but they, I think, informally will look at it. I think it depends on the philosophy of the commissioner as a mitigating factor. So those are my opening comments, and thank you for having me.
Thank you, Reggie. Before I get to Melissa, who started the first conviction integrity unit in Florida, I just want to make a couple comments because I think Melissa's going to have some detailed things to say about what her office is doing. But the reality is we all know that we prosecute innocent people. And the issue of prosecuting and convicting innocent people is not a defendant issue or a defense bar issue. It's a system issue. It's an issue for prosecutors. It's an issue for judges. But also, as importantly, it's an issue for society. Because when society loses faith in the criminal justice system, that affects the jurors that are showing up for trial and thinking about the story they just saw on the news of a defendant who spent any time in prison for not committing any crime. So the issue of innocence is an issue for everybody. And so I'm glad that we have every side of the coin here to talk about it. And with that, I want to turn it over to Melissa to talk about her role in conviction integrity and what her office is doing.
Thank you. I think we can all agree on what conviction integrity means. For me, obviously it's ensuring that we get it right, but importantly, it's also ensuring that when we make mistakes, we as a system learn from them so that we can hopefully work to prevent replicating them. And I'm going to tell you a little bit about how everything worked out to stand our first unit up. I came out of law school, was an aggressive, enthusiastic, passionate prosecutor. And I was 3 years into my career, loving it. And I was teaching at our local public university a criminal law class. And we met on Saturdays. And I worked really hard during the semester not to wear my prosecutor hat to class, to be balanced and fair in the presentation of whatever concepts that I was teaching the class. And I gave them extra credit if they would go down to the courthouse and watch a trial. And students, acting much like I did myself, waited until the end of the semester to go down and watch a trial in our courthouse. It was November. And we met on Saturdays, and this particular Saturday we were in the middle of a trial that my office was trying at the time, a first-degree murder case. And we were discussing the case and trial, and many of the students there were telling me that they had watched the trial and they believed that the defendant was innocent. And I put on my prosecutor hat and with true and sincere earnestness said, we might fail in this prosecution, but I'm here to tell you my office would never prosecute, and I believed it with every fiber of my being, we would never prosecute an innocent person for murder. The jury came back the next week. We didn't meet again as a class. It was the final class. They got extra credit for going. The jury came back and acquitted that young man. He was a 15-year-old defendant. He was identified by an eyewitness, a man who watched his wife shot and killed right in front of him, and he wrote out in his own hand a confession to first-degree murder. And at that time in my career, I won. Did not appreciate the frailties of eyewitness identification. And I certainly could not wrap my head around the possibility that anyone would admit to doing something they didn't do, much less admit to murder, and actually in their own hand write it out. Like, I could not accept that that was possible. And so, the way I viewed it was he got off at that time, right? Not that he was innocent. He had really good, competent trial counsel, and he got off. And then shortly after that, we learned, his trial counsel learned that there was information in the jail that actually somebody else had admitted to having committed the murder. And then it was discovered that there was physical evidence that hadn't been tested. In fact, this was a robbery. And so the woman's purse that was in our property room and its contents had not been fingerprinted. And on those contents were the fingerprints of Juan Curtis. And then as a young prosecutor, I watched my former trial teacher and now colleague, elected Brad King from Ocala, come to my jurisdiction because he'd been appointed by the governor's office to prosecute Juan Curtis, who ultimately was convicted and now is doing 2 life sentences. So that experience shook kind of like everything I believed to be true about the system. And while I thought I was careful before, as a prosecutor, I tell the story. My dad spent his career in law enforcement, and when I started, he wrote me a letter and told me always, like, never forget the awesome power of the prosecutor. And so I thought I was careful, but after that, it really kind of shook me. I've been in office for almost 2 years, and last year we issued an arrest warrant that I probably would have issued if it came across my desk for a young man who was accused of committing an armed robbery. And he was identified by the victim who was robbed. And he was picked up, and he spent 4 days in our Duval County jail until we learned through his lawyer that he was on playing a collegiate basketball game in Raleigh, North Carolina, on his team on the day of the robbery. So this is not to say that something happened not on my watch. This happened while I was in office, and I looked at the warrant, and I didn't disagree with the issuance of it, and I certainly agreed that there was probable cause, but what it did again is it underscored what we know to be true. This is a human system, and obviously errors are made. And what stuck with me about the Brenton Butler case was that as an office, the state attorney at the time made a public apology, the sheriff made a public apology, but we never got around the table. We never sat in a training. We never did an autopsy on what went wrong. We never talked among ourselves, and not to place blame, just to say, hey, what do we do? What did we do wrong, and what could we do going forward to make sure that young prosecutors who are learning how to handle these homicide cases maybe think through the next step? And so when I was running, even when I was in private practice, I continued to be interested in criminal justice and criminal justice policy. And I was reading about what the DA in New York, Ken Thompson, who's now deceased, had done with a conviction integrity unit. And what I read really struck me. Instead of, we didn't do this in Jacksonville because I think there's a bastion of wrongful convictions in Jacksonville that we have to fix. But what occurred to me was that I read, when a plane falls out of the sky or a train derails, there's an investigation that's done to autopsy the reason why, and for the purpose of prevention. And we don't do a great job of that, or my experience had been, at least in that case, that we hadn't done that. So I thought there's a lot of value, if for no other reason than to look back and to do a root cause analysis, or sentinel review is what they call it in this space. It makes sense to me. So the way our unit actually came to pass is I was running my mouth. I had come off the campaign trail, and I had been disciplined in my speaking, and we were with the editorial board. My chief assistant, one of my chief assistants, Matt Kevner, is here with me, and we hadn't taken office yet, but we were with our paper's editorial board. It had gone well. We were done with the interview, and one of the reporters said, hey, have you ever thought about conviction integrity? And I was so excited. We had a meeting scheduled with the Innocence project. It was something we were interested in, but we didn't have the resources, the money to do this. And I said, oh, yes, I'm so interested in conviction integrity. And as soon as it came out of my mouth, I thought, oh no. And there was a headline Nelson considering conviction integrity. And then I thought, well, this is great. How are we gonna pay for this? And so then the silver lining that came out of that is I received a phone call from John Hallway from Penn Law School. We have an academic partner in this endeavor. We worked with him and the Innocence Project on creating what I think are best practices for setting this up. And then I went to the legislature and I asked for resources. We came up with a concept paper. I met with our lawmakers. They saw the value in this and they appropriated money for it. And then this year, in January, Shelley Thibodeau joined our office and has led our efforts in conviction integrity. And I'll shut up after this. We, like Seth said, her role and this unit's role is, first of all, our policies and our threshold is very narrow. It's based on an actual and plausible showing of innocence. We've set up a mechanism by which people can petition our office to seek review of their cases. But that's the reactive part of her job. The proactive part of her job includes both the training that I've talked about, but also doing things. This year, we had a detective in one of our counties who was manipulating evidence. The sheriff promptly fired him, which was the right thing to do, but it left us with the question, well, what about all of the other cases in which he's been involved? And so Shelley's unit wrote a letter to every defendant that had pled or been convicted as a result of this officer's case, inviting them to reach out to our office for a review. That's just an example of some of the work she's done in addition to reviewing petitions. So I know Andrew's here and I think Tampa's getting ready to do the same. They don't have an appropriation, and I will tell you what has made this, I think, a good thing for our office is that it was going to be very difficult and will be for anybody else who does this without mandated or earmarked funding. It would be very difficult as the elected to tell assistants that I was going to redeploy resources that otherwise could go to them to do the job that we are tasked with doing every day. I think that would be a challenge. The fact that the legislature saw the value in this allowed me to tell our office, look, this is earmarked for this reason. This isn't money we're taking away from you or the important hard work you're doing, but we have to use it for this purpose. And so we have found internally, I think we also hired a very good person, very well respected in the bar and on the bench to do this work, respected by the prosecutors in our office. And so we've found that internally this has been met not with skepticism, but actually I think the reception has been great. In fact, some of the referrals that Shelley has gotten have come from within our own office and from law enforcement. So I said I would shut up a lot longer ago than I did.
I'm not going to tell you to shut up.
So that's
so I have to ask Seth and I have to ask Maria in any order that you want to start. How does having a state attorney's office with a specific conviction integrity unit affect the way that you represent your clients? Start with Seth, I think.
I'm going to be completely candid first. I mean, this is not about Melissa. We have seen around the country the persistence of conviction integrity units, and some are set up in ways that make them really strong and durable, and others in ways that are ill-advised. And so whenever you hear about someone wanting to set up a conviction integrity unit, you have some concern about how it's going to work and how it's going to affect the people, the constituency that are your constituency, the people who you represent. And the thing that is always, I think, the rub and something that we'll try to figure out and cause a little bit of growing pains is how to approach our cases. Like, somebody writes to us, do we take the case to the conviction integrity unit? If we're already litigating a case and the conviction integrity unit doesn't work on cases that are already on the post-conviction side of the office, already in litigation, do we dismiss the litigation and try to work with the conviction integrity unit? And that's always the hard thing. What happens when, like I'm working with Shelley Thibodeau to find a universe of old cases where DNA testing was asked for but denied or opposed by that office, and so we can maybe do some testing in those cases. And then I have cases on the litigation side of the same office where the office is opposing DNA testing. So it's not perfect, but the thing that I like about it is that it gives us an opportunity to take the edge off a little bit of the work and say, we can work together collaboratively, investigative-wise, sharing files to try to get to an answer. And if we don't agree at the end, then we can go litigate it. But if we can have this process and agree, it's going to save both of our offices tens of thousands of dollars in resources and manpower and time and years of headaches and fighting with each other, and allow us maybe to get to the right answer much quicker and more efficiently. So I think on balance, it's a tremendous idea.
Maria, have you had an opportunity to work with either Duvall's office or any other kind of conviction integrity units?
Not yet, but again, as Seth said, sometimes if the cases are in active litigation, they're usually allowing the litigation to continue. And obviously for death penalty cases, they're always in active litigation until literally the last minute. So I think maybe that's something that there can be some more communication about, potentially, like Seth said, maybe setting aside the litigation, sort of keeping it in abeyance while the conviction integrity unit reviews the case and while we work together. And sharing files, public records is a big problem in death penalty cases. We have a public record statute that is construed sort of not in favor of the death row inmate, and harder to get public records under 3.852, our public record statute, than it would be for sort of any average citizen. So I think that's something that we can potentially work together with these conviction integrity units to do. But I think that hurdle, and I obviously understand their perspective of they don't want to step on the toes of the prosecutors litigating these cases, but there has to be, I think, potentially some way to at least maybe put that litigation in abeyance and at least take an honest look at it.
I want to get into some specifics now, and obviously I'm going to leave some room for discussion and questions, but I want each of the panelists to talk about specific things that they want to talk about. And one of the things I'd like to end with when we end the panel is, where do we go from here? What is the wish list for the people on this panel in terms of the future of conviction integrity in Florida? So I want to start with Reggie, who's been working on a case that he mentioned, Felix Garcia.
Yeah, thank you. And I failed to recognize Andrew Warren, the state attorney here, who about an hour after he was certified the winner, I started sending him information. Not quite. We gave him a couple months to get sworn in and pick a staff. But all kidding aside, I've worked on Felix Garcia's case as a pro bono lawyer for 6 or 7 years. A paralegal, Pat Bliss, who's pictured with Felix here, has worked on it for almost 25 years. And certainly the state attorney's office, I believe, has been welcoming to say, share any information with us. No commitments if and when we'll get to this, but on its face, it sounds like something that we might take a look at once the conviction integrity unit gets up and running. Our theory very quickly is the following, that this was a murder for drugs and jewelry and cash at a North Tampa hotel. Felix was framed by his brother, Frank, the shooter, whose 13 prints were at the scene, his sister, who I believe was acting under duress, and by the mastermind and his sister's boyfriend, Ray Stanley, who forced her to marry him 8 days after the crime to invoke interspousal immunity. Felix was 15, 20 minutes away, had a 7-hour alibi from 6:30 at night to 1:30 in the morning. Remember signing for a pizza, watching The Godfather, going home in a cab. His girlfriend and his girlfriend's mother were eyewitnesses to his 7-hour alibi. The murder, the state stipulated, took place between 8:15 and 11 p.m. The outline goes into a little bit more detail, but essentially they used Felix's ID at the pawn shop to pawn some of the stolen jewelry. His brother implicated him to avoid the death penalty and did. He was convicted of second and armed robbery. He'll be out in 6 years. We've convinced DOC to send Felix to Virginia because he's deaf, and they do a little bit better there with the inmates there. But it just illustrates that, and then his brother and sister eventually recanted. It went back to circuit court with new evidence and was unsuccessful. But to me, it's the kind of thing, once Fox did a 6-minute story on this, I got a text and a phone call from a new fact witness that said the 3 people, Felix's brother, his sister, and his sister's pimp, went to her house at 11 or 11:15 that night, which perfectly coincides with our theory of the facts of the case, and that Felix was not with them, and all three of the other people were high on drugs, bragging about killing somebody. So does that mean he's 100% innocent? I think it does. Obviously, prosecutors and judges have to make their own judgment, but it's important because it's a pending clemency case as well as a pending parole case, and it is just these types of cases, and what I heard Nina talk about this morning, and again, not to fault anybody, I think everybody did their job, but I don't think in 2018 a deaf person with a 4th grade reading comprehension and listening skills would go to trial for first-degree murder without a sign language interpreter. We just saw all the hurricane briefings by the governor. There was a sign language interpreter, and most legal and medical events have them, but this was 35 years ago. And instead he was given a loudspeaker and a hearing aid, and it confused him more than anything. Again, I think everybody was doing their job. It was just a wrong result, and I think one day Felix will be free. In the meantime, he's a sweet man serving time in Virginia, and we hope to get him out soon. Thank you.
Maria, did you want to talk about anything specific that you're dealing with right now in the area of conviction integrity in terms of your post-conviction litigation?
Well, sure. There was a case I sort of touched briefly on in my opening. Again, the client is from 1976, and there was a piece of hair. The only physical evidence linking him to the scene was a hair that was the subject of microscopic comparison. Obviously, as many of you know, the FBI report came out a couple of years ago now saying that, that's junk science. We filed a motion challenging its conviction based on that. We sought DNA testing. It was the DNA testing was opposed by the state, and we have yet to get DNA testing on that hair. This is the only piece of evidence linking our client to the crime scene. And so that's something I think it's a simple DNA test that could be done. And this is a piece of evidence that was used, the only piece of evidence linking my client to the crime scene. And so for me, especially as a former prosecutor, I'm not coming at this, I've sat with victims. I understand the need for finality. But to me, a big flaw in the system is just this stonewalling about DNA testing when it can really provide, definitive evidence. And I understand finality. I understand the need for finality. But are we really comfortable with a system that, again, potentially allows for the execution of an innocent person just for the sake of finality?
And Melissa, we talked about this a little bit before, but how do you deal with that, which is a case where you have a conviction integrity unit, you have an assistant state attorney in your office who firmly believes in the guilt, the family of the victim firmly believes in the guilt of the defendant, the evidence kind of looks a little bit different, and you're determining where to go. How does the unit play in there, and how do you work with that kind of emotion versus fact in the case?
So we're very young in this right now. Shelley's been doing this since January, and the first couple of months was spent drafting policies and procedures about thinking through different hypotheticals and what would we do and how would we deal with this set of facts. We haven't faced that yet, although certainly that could be possible. We did think through and discuss, when do we tell next of kin, because we're very sensitive to the fact that if Shelley feels it appropriate to look at a petition, we do not want to upset someone and let them know we're looking at something that she may get to the end of the line and say, I'm not going to do anything with this. So we thought through, when do we notify next of kin? When do we notify the underlying prosecutor? And we built out procedures such that both of them, if we deem fit to notify them, and we do, have the opportunity. We've set up an independent advisory board that Shelley will write a report to, and this board will actually listen to evidence and hear her report, and there, both the prosecutor and next of kin will be able to address that board. Our policies are on our website, but I took them down right before we met because I saw a little grammatical nit and font size, so we'll have them back up tomorrow that you can look at, take a look at. And we encourage too your feedback, because when we met with this board, for example, Hank had some really good ideas and things we hadn't yet thought through. So if you take a look at it and you have some thoughts of things that perhaps we haven't thought through or questions, reach out to us.
Well, let me just ask you on that, and Shelley, if you want to grab a microphone and answer this question. My question is this: how do I get to the conviction integrity unit? Is it a defense lawyer files something? Is it a defense lawyer calls and says, hey, I think my client's innocent? I know Melissa mentioned law enforcement has contacted, but how are you funneling in these types of issues for review in your office?
In our office, sorry?
I have a wireless one here, so.
Okay, so in our office, I have put a petition on our website, and I'm asking everybody to fill out the petition just so that I have the same information for all the cases. And so at this point in time, I've had about 180 letters, petitions come into the office. I would say 97% of them are from inmates or the convicted individual directly. I've had about a dozen come from defense attorneys. I've had a couple come from in-house prosecutors who maybe are dealing with a violation of probation, and they're now looking at the underlying facts and are becoming concerned about it, or the defense attorney has said something to them. And so I've had a couple people send me things internally. And then surprisingly to me, because I know this active JSO detective well, I had a JSO detective reach out to me a couple months ago and say that something had come across his desk. And while he wasn't the detective that originally handled it, it was of concern to him. And so then he forwarded it to my office. So we're having petitions come from a wide variety of different places.
Let me just grab, I have one more question for you. One more question I wanted to ask was, how does conviction integrity play into training young assistant state attorneys? Do you have a component in the unit where the new class of hires gets sat down and you talk about Brady and you talk about DNA and other things like that?
Yeah, we've talked about that the conviction integrity unit in our office is going to have dual roles, the reactive component and the proactive component. I haven't actually started actively training in the office as of yet. I think the idea originally was that I would get my feet underneath me. I was a 22-year defense attorney, and just the whole concept of going from defense to the prosecutor's office, drafting the policies. I've responded to all of the 180 petitions at this point. I'm not actively investigating 180, but I have responded to all of them. So it's been very time consuming. But I think this coming year, the concept would be that we would start actively providing training to the attorneys. I have spoken to new hires and sort of introduced them to the conviction integrity unit and discussed with them the goals for the unit. One of the goals this coming up shortly is to address the discovery rule change, and that was mentioned at a previous component of this about the jailhouse informant database. So we're in the process of establishing policies and procedures to get a jailhouse informant or an informant database up and running so that we can comply with the discovery change. Our office has a Brady checklist, and so I was looking at the Brady checklist. So there are components and pieces that we hope to implement, in the new year.
Thank you. Yeah. Before I move on to some issues of the future of this, do we have questions? We've been going for about 45 minutes here. So, Adam, do you want me to give him the microphone? Is that? Okay, great.
We've heard some discussion about when there's a change in science that can affect how we look at an old conviction. Quote unquote shaken baby cases come to mind. Have you all given thought to how you will deal with a change in the science?
Okay, so the question is, has this panel given a thought of how they will deal with the change in science when it comes to things like shaken baby syndrome? So I saw Melissa wanted to answer that, so go ahead.
Oh, I thought it was, I don't have to.
No,
direct
I'd like you to
okay.
answer, yeah.
So yes, we have given thought in terms of sources of cases. We were told early on, I think this came from Nina, that cases may come to us through the defense bar, the defense attorney who says, I've been practicing for 35 years and this is the one case that keeps me up at night. And defenses can be the proactive bucket where we need to look back. Honestly, we've been so busy receiving, we haven't had the time to look back. And we've actually talked about, for example, arson cases, and then we've struggled with how do we identify those people in prison convicted from our jurisdiction on arson evidence other than institutional knowledge, and someone saying, hey, I remember this case. Yes, we're open to that. It's not a step we've taken yet.
Seth, I know the Innocence Project has been dealing with other than DNA type of cases. Can you talk about that?
Sure. I mean, we started out as a DNA-only project, but as DNA testing has occurred more often on the front end, we realized that we needed to get with the rest of our colleagues and the rest of the country and look at cases that rely on still evidence of actual innocence, but that don't have a DNA component. And so really they can come from anything. It could be witness testimony. It could be somebody recanting a confession, someone else confessing to a crime that was not the person who was convicted. But also we're looking at cases similar to what Adam Tabrouge mentioned, cases where there might be a shift in our understanding of certain sciences that suggest not that someone else did the crime, but that a crime didn't happen. Arson cases, cases that deal with medical diagnosis. And so those are complicated. We don't have, and we're building expertise in those cases, but they're expert heavy, they're expensive, so we have to kind of ration our resources because we have to pick wisely in those cases. I wanted to talk about one other thing.
Go ahead.
If that's all right. One of the best practices that Barry Scheck talks about in his article is approaching post-conviction innocent cases from the perspective of, if I had this new evidence back then, would we prosecute? And doing that inquiry without respect to procedural bars. And for those who hear and practice post-conviction, they know that when an inmate files a post-conviction motion, the first question that the prosecutor and the court often asks is, putting the merits and the substance aside, is there a procedural way to not get to the merits of this case? And oftentimes in our cases, where we have evidence of actual innocence, they're just old. And we can't get over the burden of saying, hey, we should, maybe we should have found this evidence earlier, but this person, this evidence demonstrates they're actually innocent. And so one thing that we're kind of struggling with, and we're hoping that this conviction integrity model can perpetuate, even if you can't stand up a conviction integrity unit in your individual prosecutor's office, is this notion that we need to be looking at these cases, putting aside procedural bars and trying to understand, do we have a person here who is innocent or a person that we shouldn't have prosecuted? Because if we answer that question yes, then the idea of finality and the idea of procedural bars should take a back seat, I think, to doing what's right and doing justice. And so we've had a number of cases where the prosecutors took those approaches, and other cases where we've had similarly situated evidence where we've lost in court, or we can't go to court because we can't make a good faith showing that we couldn't have found this evidence earlier than we did. So I'm hoping that that is a residual effect of this conviction integrity effort, and that's something that can spread to all state attorneys' offices.
Other questions? Yes.
And this is probably best for Melissa, but has there ever been any thought of the conviction integrity unit to go beyond this actual innocence? Because the cases that keep me up are cases that I see that the perfect storm happened, and there's an absolute terrible disposition, and it never should have happened. Does finality always trump that?
So the question is whether the conviction integrity unit has any plans to deal with cases other than actual innocence.
So there are units on the East Coast and actually West Coast that are looking at things beyond actual innocence. We are not. We are right now Shelley and an investigator and Shelley. And so, and some intern support. So we, and I also think anytime you do something like this is new for a prosecutor's office, we want to make sure we do it right. We did not want to start so broad that we would not serve benefit or value to anyone. So we're not. That's not to say there might not be some time in the future. So absent a showing of actual innocence, we are not reviewing cases of disproportionate sentences, because obviously we've heard from a lot of people asking us to do that.
Carlos.
In Miami-Dade County, we have a situation that I think they also have in the 14th Circuit, which were very corrupt cops, and we have an entire police department. And the question that I have for you is, I can understand, trying to limit the cases of innocence, but at some point, we're trying to figure out right now, there are more than 2,000 cases that were impacted by 4 corrupt cops. And we're trying to figure out right now, how are we going to prevent this from happening, which was the second point you made, is you're learning from this, how do you prevent it? And there are some things that we're learning from it, and I think it would be useful. So for example, as defense attorneys, a lot of times we're filing a motion to suppress because we're saying there's a violation of the Fourth Amendment right and how it stop happening and all these things. Looking backward at this police department, we can actually see a whole slew of things that none of us would have caught unless the people have been complaining about it. For example, they were the #1 police agency in the entire state of Florida, getting awards for ticket or ticket. So they were stopping people for violations of the seatbelt law. And every single one of those cases that we've looked back on are cases of felony cases. There were actually cases that motions to suppress were filed about the stop, about all sorts of things that happened. Do you see a role for prosecutors? Because the system, most people have contact with police, and what's happening on the streets is getting stopped. The bike issues, but the bike right now. So do you see a role for prosecutor offices going forward if the legislature funds it? Obviously, they would need to fund it, trying to improve the integrity of the entire system by going after these cops that are doing these things on a pretty regular basis. And you may not go after them criminally, but we may have to do some things to stop that behavior.
Can I ask a question, Carlos? And this is Carlos Martinez, the elected public defender in the 11th Circuit in Miami. My understanding of the Biscayne Park case is that it was discovered after it all happened. So I guess what I'm asking is your question, are you asking whether Melissa's office or any conviction integrity unit would be involved in a case like this at the time it was discovered, or there's ongoing cases and a defense lawyer comes to the unit and says, I believe these officers are corrupt and here's my evidence, and the cases are still pending?
What we're finding about Biscayne Park is that it was not after the fact. That it was happening, and there were different people that knew about it, and they did very little about it. And then, thankfully, there were some police officers who reported that to the city manager, even as they were working for the department, they were collaborating with the FBI. So the issue would be, it's all of it. It's as it's ongoing, and after the fact as well, when you look at a whole department and you see all sorts of terrible practices.
Well, let me add to that, and we'll get into this now, because one of the things I told the panelists is we're going to talk about our wish list, and that is how we would like to see this in the future in terms of what we're doing for conviction integrity. So I guess, Melissa, I'm asking, I know what your unit is now. It's Shelley and an investigator and a couple law students or college students. But in terms of what Carlos is saying, that there's corruption out there, and then somebody comes to your office and says, hey, you need to look at this right now. Maybe all these cases need to be dismissed. Do you see a future for that type of thing other than just a post-conviction? This guy was convicted and sentenced and he's innocent. Do you see that coming into the unit, or is that for something else? And then you can go into what is your wish list for your conviction integrity process?
Certainly, if we discovered or received viable allegations of police corruption. My understanding is that's how Ken Thompson's Brooklyn's conviction integrity unit was actually born, was because of a law enforcement officer that they discovered, and they proactively decided to look at all of his historical cases. So we have not been faced with that. If we were, I would expect that that is work that the conviction integrity unit would do. I will say that the majority of the attaboys we received when we stood this up came from law enforcement. Emails and letters congratulating us on doing this. So I think they value it. As to your question about police practices, there's space too, certainly. Shelley has, by doing this as well, created a nice network outside of Florida as well, with her contemporaries who are also doing this work, and she's paying attention to what's going on in the United States. And so there's definitely space for us to share training and ideas with our law enforcement partners. As to my wish list, it's not, what do I want in terms of resources? It is my hope that this endeavor is, I think we've gone about it the right way so that it has the credibility it needs to be successful. And my hope is that it will have the credibility it needs in the public when we make announcements or handle our first case. I hope that people engage with us and give us their feedback. I hope we do good enough work. I'm very pleased with what Shelley's done so far, that we can become a model for other offices. We really, obviously, there are 30 other offices in the United States, and so we've modeled many of our practices taken from different jurisdictions that we think would work for us. I know that some of the lawmakers that I talked to when we asked for this, they were interested in what North Carolina has done, potentially long-term, legislating a state commission on innocence, and that would actually take it out of our offices and allow a separate independent entity to do this work. And so perhaps this is where this goes. One of the things that Shelley committed to is annually filing a report to the public about the work she's done over the course of the past year, so the public can see what in fact we've done. So I guess I don't have a wish list so much for things or money as much as I do just that this ends up to be the valuable and good endeavor that we hope it to be.
Maria, your wish list.
Well, I think better communication between state attorneys and my office, access to DNA testing, elimination, like Seth said, of procedural bars in actual innocence cases, and better access to public records in these cases, not sort of standing behind shielding some of these high burdens and death penalty cases to get public records. So I guess I really just think open communication, increased communication between the defense bar and the state attorneys.
Can I ask you specifically what you mean? I'm a defense lawyer. When you talk about communication, is it you're not getting emails back, you're not getting phone calls back, they're not responding to things that you're writing or filing? What are you specifically talking about?
Well, so I think in a lot of cases, in the death penalty cases, once the case gets out of the circuit court and is in the Supreme Court or federal court, it gets passed off to the Attorney General's office. So the local state attorney's office, while they still have jurisdiction, and if there's a warrant, they're litigating it as well, they do sort of take a step back, and they're the sort of keepers of the evidence. They're the ones that really need to be looking at these cases. So I think it's more of you reach out to them and they're like, well, it's, the AG's litigating this case, or it's just sort of being able to take them a case and say, look, this is something you need to look at, and them listening and looking at it and not just saying, well, I defer to the AG.
Reggie.
Thank you. And I'm the son of a deputy sheriff, and so thank you to the law enforcement folks here and all the elected public officials here. I saw Chief Judge Figueroa yesterday, and he's a longtime college friend, and I see my friend Julie Holt and Andrew and his team. But two very specific things. The legislature tells the Florida Commission on Offender Review exactly what statutory aggravators and mitigators they can consider. And while I think it's nebulous enough that they can consider actual evidence and new facts currently as a mitigator, certainly we could work on language, maybe with the bar and Factual and others, to just make that explicitly clear Doesn't have to be dispositive, they're not bound by it, but certainly if one of your offices is 70 or 80% of the way there and thinking there's at least some new evidence that should be considered, I would think we'd all have a vested interest in at least making sure the 3 parole commissioners could consider that. Related to that, but on the clemency side, get ready for this. There are 23,000 pending clemency cases before they open the mail today. And half of those are restoration of civil rights cases, which if Amendment 4 passes, maybe future ones will go away. But a modest increase appropriation of $500,000 to $1 million just for additional investigators, because the Commission on Offender Review, this is not well known, in addition to their direct decisions on parole, investigates every single pending clemency case that the governor and cabinet ultimately decide. The last pardon I argued, and Richard Greenberg does these in March, took 12 years. We can permit 300 marina boat slips in condos in Pinellas County in 3 years and still fuss that it should have been 2 or 2.5. So regardless of where you are philosophically on this, I think we can all agree that if there's 23,000 pending clemency cases, there's got to be some increased resources to help get that backlog moving. Thank you.
And Seth, I know your wish list is that there be no innocent people convicted, but specifically what is on your wish list?
Sure. You know, the one upshot of having over 2,200 known innocent people who have been exonerated since 1989 is that we have a data set to help us understand how those individuals got wrongfully convicted so we can address those causes. And one of the things on our wish list for a long time was eyewitness identification reform. Let's talk about eyewitness misidentification as a leading cause of wrongful convictions. And the legislature, after a number of years of trying, addressed that in 2017. Our next thing on our agenda is to pass mandatory electronic recording of interrogations in certain felony cases. We strongly believe that understanding the reliability of a confession is largely determinant on understanding the nature of the interrogation that happened before that, that led up to the confession, and having all parties, including the fact finders in court, understanding that can help us root out false confessions. It can also help us, it could probably lead to more pleas in cases by having actual confessions that are reliable, having proof of them, and allowing those cases to be fettered out of the process and not go to trial and save us resources. So we feel it plays a dual role to both protect law enforcement, create greater efficiencies in the system, and help prevent innocent people from going to prison. So we're hoping that passes this year.
Let me ask you a question before I open it up for questions. We've got about 10 minutes left, but I've been involved in the recording of interrogations fight for many years in the legislature. Have you noticed a change based on the body cams that are out there? Have you noticed that law enforcement is taking a different position now that they're basically 24/7 wearing a body cam?
I think so. Certainly, we've seen that certain segments of the law enforcement community have come on board where maybe 5 or 6 years ago they, at least viscerally, were not in favor of this. I think also it's important to say that individuals who are in law enforcement who are the subject of an internal affairs investigation, those are required by law to be recorded. So we've always thought that regular citizens should get the same benefits. And so, but yeah, I think International Association of Chiefs of Police recommends this. Many states require it, either by law or attorney generals have required it. So we're getting there, and I think we'll be able to get there hopefully this year.
Questions? Yes.
So once the conviction integrity unit identifies a case that where they think somebody was wrongfully convicted, let's say there is a procedural bar, how do you get it back to court? Like, what's the mechanism for correcting that?
I was hoping, I figured
Let me
somebody.
so the question is, what does the conviction integrity unit do when a case is presented where there is a procedural bar?
So right now, what we envision is that we would actually, Shelley's smiling because we've talked about this, and we've talked about this actually with our judiciary, that we would bring the case back. We would file a motion to vacate I don't think I envision we won't have opposition when we, when and if we do that, but it's a great question, so.
Other questions? Yes.
Do you have to call the victim when that happens, and
We-
does that have an impact on your decision?
Question is, do you have to call the victim?
We absolutely, we are going to, in everything we do in our policies, speak to this, how important it is to make sure we are communicating with next of kin and providing them an opportunity to be heard. So yes, absolutely.
Yes. Sandy.
Andrew explain what they're going to do in Hillsborough. I already asked him.
It's Andrew Warren, the elected state attorney at 13th Circuit, Hillsborough.
Sure, can you hear me?
You want have a wireless mic. It'd be easier because they're recording this.
Hi, we're copying off Melissa. Actually, Melissa and I have talked with groups from around the country following best practices, as Seth alluded to before. So we just hired the attorney who's going to be our Shelley, who's here, Teresa Hall. We have an independent review panel set up that some offices engage in. We're finalizing our screening process, our review process. We too are going to have a single attorney, a single investigator, single paralegal. We have a partnership with USF to get students to help with some of the screening. But the basic formula is the same when you follow best practices. So there's some devil in the details about how exactly we do it. We're probably going to announce ours in the next month or so once we've given Teresa some time to figure out how to best copy off what Melissa and others are doing. But it really is exciting as more cities and more counties are embracing this idea across the country to do what we're supposed to do, which is to make sure that we're actually achieving justice within our offices.
Thank you, Andrew. Yes.
Working with the public defender's office, one of the things I've suggested is when you have a situation with an officer that we don't agree with either what he's done or we're not really sure that he's telling the truth, to write memos on those specific cases. And we keep those memos and gather enough to the point where either the supervisors think they have enough to pass off to the prosecutors, or we get one that's severe enough that we then pass that one along with all the rest that we gather. If that was something that was presented to the integrity unit, would that be something you guys would even looking into that officer to make sure that he is doing what he's supposed to?
So the question is, if the defense lawyer, public defender's office keeps track of law enforcement activity in the form of memo or other written documents and presented it to the unit as to what was going on, would you review that?
So we've actually already experienced that. The officer I referenced earlier, the information came to light through the public defender's office. The public defender's office, I think Mac went straight to the sheriff's office with the information, but it was acted on, and that was the source of the information. And then we subsequently found out the body of convicted defendants who intersected with that officer and sent all of those folks letters, and that came out of the unit. So yes.
Yes.
I actually have a case pending, conviction in Jacksonville, and one of the issues, and it just came up, the procedural matter about, how you give the case back to the court. So my question is, probably for Reggie, would it be prudent for someone to submit an amendment to the Florida Rules of Criminal Procedure for that to take place? When and if there's a situation or circumstance whereby the proper case is before the state attorney office, they agree that it probably should be retried or reopened or whatever, will make it more objective to have a rule in place that can be tapped into.
So the question is whether the Florida Rules of Criminal Procedure should be amended to assist in this conviction integrity process.
That's way out of my lane. I defer to Melissa and Shelley, and I'd love to hear the answer. Or Seth.
Go ahead.
So before any conviction integrity units, our office, some of the exonerations we've had have been by stipulation. And I think we ended up in the end point in a similar fashion that a conviction integrity unit would get there, particularly with someone who's represented by counsel. So I think I think the law, even though it's not explicit on this, contemplates a space for a joint motion to vacate conviction under Rule 3.850 or 3.851 in a capital context. And so I don't know that that's a huge issue. And I will say that, if your elected state attorney, via their head of the conviction integrity unit is going into court and saying, we believe this conviction should be overturned, here's our motion, the state's motion to do this, I mean, it's happening. It's going to happen in my experience of exonerating lots of people. And so if the state attorney agrees to it, it's happening. So.
Just to follow up, the reason I brought that up is because there was a specific discussion about the vehicle to get that back in the court. My case was tried in 2010, and so they've been very helpful and congenial and everything else. So, but it was a logistical issue that I was discussing with one of the prosecutors. If we do agree to this, how do we get this back in the court? And so I just thought about an objective means by which to do that could help everybody in the future if we're going to move towards these types of cases. That's why I love it.
Other questions? Yes, Andrew.
More of a suggestion than a question. Melissa and I had the opportunity to sit down with exonerees in the past. I know, Seth, you do this on a regular basis. But I would encourage people from other jurisdictions to reach out to groups like Witness to Innocence to invite them into their jurisdiction, because it really is eye-opening for a lot of prosecutors and law enforcement officials when you're hearing from someone who is sitting on death row for a crime that they did not commit.
Thank you for that. Okay, anything else? Any other questions? This has really been an honor for me to do this. Thank you, everyone. Thank you, panelists.